No parchment in Philadelphia bore the words Judicial Review, yet for more than 2 centuries, every law in this land has bowed before it. Picture Chief Justice John Marshall in 1803, sitting inside the old Supreme Court chamber on Capitol Hill, pen in hand, writing that the court must say what the law is. The ink was dark, the room hushed. Outside, few knew the Republic had changed forever, not by war, not by vote, but by sentence. How can a court claim a power not written in the law? To answer that question, we must first see why men like Marshall believed silence could carry command. They turned to Article III, the briefest of the articles. It granted the judicial power, in all cases arising under this Constitution. Alexander Hamilton, in Federalist No. 78, reasoned that when 2 laws conflict, one higher than the other, judges must prefer the higher. The Constitution, being supreme, must guide their judgment. Without that rule, a written charter would be no more than paper. Picture Independence Hall in 1787. The summer air thick, quills scratching, delegates weary. The framers debated how to keep power chained to principle. They chose checks over crowns. Yet they wrote no sentence giving courts the last word. Their aim was balance, not supremacy. Out of that silence, Marbury vs. Madison bloomed. A small dispute over a forgotten commission became the seed of a vast authority. Marshall's opinion declared an act of Congress void. He said the court's oath bound it to the Constitution above statute. Thus began the long habit of judicial review, the habit that steadies, and sometimes unsettles, a free people. Half a century later, the Dred Scott case reached the Supreme Court. Picture the marble steps in Washington, 1857, as the enslaved man's name echoes through the chamber. The court ruled that he and all his race could never be citizens. It sought to settle by decree what conscience refused to yield. In that moment, the court used its power to close debate, not to keep faith. I remember how that opinion spread like a shadow over Springfield, Illinois. Farmers and merchants read it by lantern light, uncertain what the Union stood for. The robe had spoken, the nation trembled. When I took the oath of office 4 years later, standing on the east portico of the Capitol, I honored the court's duty, but denied its dominion. I said that if national policy on vital questions were fixed by Supreme Court rulings, the people will have ceased to be their own rulers. A republic cannot lease its conscience to 9 men. Government of the people must think as well as obey. Still, respect for law is the anchor of liberty. If every citizen judged by private opinion, law would perish in the noise of zeal. So the balance must be kept between courts that guard and a people that govern. Imagine the old chamber again, gavel striking wood. A judge looks not upward for final rule but outward, to the text, the reason, the cases before him. His task is narrow but noble, to keep each branch within its bounds. Judicial review exists not to create policy, but to preserve promise. The power works best when paired with humility. Each time a generation confuses interpretation with command, the nation reminds it that power, like water, must stay within its banks or destroy what it serves. The Civil War itself proved that lesson in fire. Picture the torn pages of law books at Appomattox Courthouse in 1865 beside stacked muskets. Men learned then that no decree, judicial or legislative, could stand above the moral law that declares all men free. Constitution and conscience met again, equal at last. So the question remains, who decides the last word, the court or the people? The honest answer is both, within their spheres. Courts declare what the Constitution means in cases. The people declare what the Constitution shall be through amendment and reasoned vote. Each checks the other. Neither may reign alone. Between them lies the steady rule of law. Think now of a small-town courthouse. Brick walls faded, flag hanging still. Inside, a single judge listens to 2 neighbors quarrel over a fence line. The same ideals that stirred the High Court guide that humble bench: fairness, restraint, duty to truth above favor. Judicial review at its core is not grandeur, it is conscience in practice, yet conscience must answer to humility. When courts forget that the people are the authors of the Constitution, they lose moral ground. When the people forget that law protects them from momentary passion, they lose liberty. Picture schoolchildren in Des Moines, Iowa, reciting the preamble on worn classroom desks. They name "we the people," not "we the judges," nor "we the Congress," nor "we the President." That phrase is the origin and end of authority in this land. Every clause, every right, every rule springs from that beginning. Power forever longs to grow beyond its limits, yet liberty must also guard the courts that claim to guard it. Picture once more the justices assembled in their black robes beneath the high dome of the Supreme Court. Behind them, carved in marble, the words "equal justice under law." That promise binds each citizen and each branch alike. Only the habit of self-restraint in service of the people keeps the robe from becoming a cloak of command. I have often thought of George Washington's farewell at the end of his presidency. He warned that the structure of government is but the form of virtue. It cannot supply the spirit. The same applies here. Law may set the frame, but only moral sense keeps that frame from tyranny. No parchment, however well written, can preserve the Republic if hearts grow careless to its meaning. When the Civil War ended and the new amendments broke the chains of slavery, the courts faced again the test of measure. Would they shrink liberty into narrow reading, or would they breathe life into the broad promise of equality? Some did one, some the other. Imagine the year 1954, the Brown versus Board of Education decision read aloud in Topeka. Parents standing in a crowded hallway, children peering through classroom doors. The court ruled that segregation had no place in public schools. Here, judicial review again turned from restraint to courage, and conscience blessed it. Out of one pen stroke, the long march toward civil equality found new ground. For there is this danger. When citizens grow idle, courts must fill the emptiness. When citizens stay active, courts can rest within their proper task. The strength of our institutions depends not on parchment alone, but on participation. To live under law is not to surrender thought. It is to promise that when passions boil, reason will cool them. That when leaders strain for power, another branch will say, "Thus far and no farther." It is a grand design, three balances bound together by one people who choose patience over impulse. I recall my own time in the White House, nights when the Capitol dome glowed through smoke. I would walk toward the window and look upon that light, wondering how a nation could survive its own fears. The answer, then and now, rests in a citizen's quiet courage, to trust truth enough to hear both its defense and its rebuke. Picture an elderly voter in a wooden booth in Springfield, pen hovering over a ballot, whispering a prayer before marking her choice. That act, humble though it seems, guides every court and Congress more surely than any decree. It is the people's review, the lawful judgment of the governed. So let every generation study the Constitution not as scripture of power, but as covenant of purpose. Read its clauses with respect, not reverence for men, but reverence for principle. Protect the independence of the judiciary, yet remember that independence is not immunity. Let courtrooms shine with reason, and town halls echo with truth. Freedom requires obedience to law and oversight by the people who ordained it. And so we return to where we began. No parchment ever wrote judicial review, yet the phrase came to guard the living heart of the Constitution. It was born from silence, matured through trial, and survives by faith. That power may guide, but people must rule. Picture the flag over the Supreme Court at dawn, its folds stirring against the stone. Within that building sit 9 citizens, sworn to duty. Beyond its gates walk millions, sworn to liberty. Between them flows the fragile thread of trust that holds a free nation whole. Hold fast to that thread. Let neither pride nor anger cut it. Treat judgment with humility, disagreement with dignity, and law with love, enough to correct it when it errs. For only then will law serve justice, and justice serve peace. The Republic can be saved. When that moment comes again, and it surely will, when courts test their bounds and the people must weigh their patience, what will your answer be?